Thank you for being here. My name's Veronica Darling, and I am with Cultiva Law. Before we get started, I just want to give a shout out to Sarah Battersby. I hope most of you were at her talk earlier this morning. She's an incredible advocate for the hemp industry and the industry in general. And I know that she did some stuff on hemp contracts. I'm happy to pick up where she might have gotten into detail and give you a more general overview. And she's an incredible person to talk to if you want to talk fundraising and investments and equity. And I'm going to get my water. So how many of you are growers? Processors? Great. So one of the reasons I decided to talk about this today is that in the last few weeks, literally, it has just been as if we've been inundated with questions from growers who find themselves without product. And they had a great harvest. They made it through the rains. They have buyers. They have people who want their processed material, and they can't get it back from a processor. There were many different reasons why, but in general, it came down to the type of contract that was in place with a processor. And so we wanted to make sure to go over each of the scenarios we're seeing come up and explain to you how you can avoid those situations in the future and tell you a little bit about each one of those cases and how the issues came up and how they ended up shaking out. And, at the end, of course, hopefully give you some insight into how you can protect yourself in the next harvest to make sure that your material actually, that is processed, gets back to you. So, quickly a little bit about me, bear with me. I grew up in the Pacific Northwest. I went to school at Washington State University Pullman and went down to LA for law school. I worked in LA for about 13 years as a litigator and just got burned out on, first of all, being in a place that only had one season when I grew up here and was used to, at least 2 seasons, some sunny and the majority rain. When I started practicing in LA, I worked primarily for a private law firm that did all work for public agencies. We were on the city and county and state side of things. And I happened to be with that law firm as we were witnessing the first wave of cannabis in Southern California, where we were legalized for medical, and a lot of our clients who were cities and counties and municipalities in Southern California didn't want to have any dispensaries in their neighborhood. They didn't want any sort of co-op. They wanted to write laws that kept it out of their city. We had to advise them on how they could and could not do that and how to go forward and how to meet the needs of their constituents, because in a lot of cases, their constituents actually wanted co-ops and wanted dispensaries in their neighborhoods and in their city. So after working with that law firm for about 3 years, I moved into just focusing on business transactions and contracts and still regulatory law, but representing the business side of it. And in 2014, as I was starting to feel really burned out on being in Los Angeles and being a litigator and not feeling like my job did anything to make the world a better place, one of my acquaintances from college was in Portland and had been one of the first wave of medical marijuana patients in Oregon and was starting her own edibles company. And she was terrified. All of the regulations were scary. It was just the OMMP market. They were working out of their kitchen at home. And we ended up having daily conversations about the regulations, how they were changing. If she started selling product, could the feds come and seize her house because she was a homeowner? And all of those fears that I think everyone remembers back from 5 or 6 years ago when things started really moving towards the recreational market in Oregon. It was really scary. And in spending those days talking to her and, basically in my free time, I realized how much I loved helping her build a business that I thought made the world a better place. And it really coincided with me being done with LA. So I packed up the cats and the Jeep and moved back home in December of 2015 and spent the next year helping get the company off the ground, walking them through the OLCC process and going to meetings and understanding regulations. And they happened to be in the city of Portland, so we also had to deal with BDS and trying to get a CO2 extractor licensed and permitted by BDS when they had never seen a CO2 extractor before, and trying to explain to the fire marshal and the city of Portland what a CO2 extractor was and that it wasn't as dangerous as it sounded, and putting it in a closed room is probably a really bad idea, but we figured it out. and we got up and running, and the company is doing really well. And as I kept working in private practice for my law firm in Los Angeles, but the more and more I did litigating just to pay the bills, working for those private business clients that didn't have anything to do with the cannabis or hemp industry, the more I realized I wanted it to be a full-time gig. And I started making the move towards being a full-time in-house or I did in-house for a while, and now I'm outside counsel, cannabis attorney and hemp attorney. I joined Cultiva Law in 2019, and I am so happy to be here. I am so thrilled to talk to all of you. And on a personal level, right as I decided to make the transition to being a full-time cannabis lawyer, both of my parents, within 6 weeks of each other, were diagnosed with stage 3 and 4, respectively, advanced GI cancers. And they're doing great, don't worry. But the thing that's been fantastic about it is, after being in this industry and working on the business side for 3 or 4 years, I got to see firsthand how what you do as growers and processors in the hemp and cannabis industries helps people get through what they do to cancer patients, for those, especially for advanced stage cancers. They are doing great. Their quality of life has improved. We've gotten them through surgeries and chemotherapy and radiation. And it's because you grow what you do and you put it out in the marketplace, and you're willing to do the scary thing that may or may not be federally legal, that may or may not be popular in some areas. And thank you for doing that. And also, as a kid who was like a 90s grunger and a rebel in the Pacific Northwest, to have my Christian evangelical missionary parents call and ask me to bring weed the next time I visit is one of the coolest things that has ever happened to me. And we laugh about it so much. And I will never forget the time I brought a tincture to my mom, and she was so excited about it. And she looked at me and said, "Can I have it right now?" And I was like, my mom is doing the weed right now in front of me, and she's really excited about it, and it's really helping her life. So thank you for letting me tell you a little bit about me and about my parents and how it's helped them. And let's get to what I consider the really fun stuff, the contracts. So, hemp processors. Today, when I'm talking about hemp processors, what I mean is the stage between the harvest and the consumer, the retailer. Sometimes that means just harvesting and drying. Sometimes it means turning it into oil, distillate, all of those things. I'm not going to get down in the weeds on what we do with the harvest. I want to talk about the relationship between a grower and the processor who does that interim step, whether or not that product comes back to a harvester, a grower, in order to turn it into pre-rolls or just flour or whatever product line you have going. I'm not going to get down in the weeds on that. I want to talk about that relationship and how I've seen it both go well and go not so well, and what you can do to protect yourself and your company. So importantly, what I want you to remember, and I think what's getting lost in the shuffle, is I see a lot of growers not remembering that without them, the processors don't have a job. The processors don't have product to process unless they have a grower. You are not a dispensable party to all of this. You're really important. We don't have an industry without you. My parents don't have medication that helps them with their cancer symptoms and their treatment symptoms without you. So remember that while the processors right now, I think, have been in a little bit of a position where they've got so much influx of growers and so many people that got into the market that they can pick and choose and treat people how they want to treat them, in reality, the relationship is symbiotic. You have to work together. You don't have one without the other, and the processors need you as much as you need them. So there's 3 types of contracts that we've seen coming our way. You've got a handshake agreement, which lawyers call an oral agreement. We also have had very, very simple looking, generic written contracts. It looks very professional, kind of looks like something you probably got off LegalZoom. Or, maybe you had an attorney help you draft it, but it has headings, it's bolded, it looks pretty professional. Everyone sees a heading that makes sense to them and they think they should sign it. And then we've seen more detailed written agreements that are specific to the product we're talking about, the harvest we're talking about, down to the percentage of THC or CBD that's going to be in the product, what the yields are going to look like, and how those things are going to be split between the processor and the grower. So in scenario 1, we've got the handshake agreement. Like I said, it's also known as an oral agreement. This grower had nothing in writing. It was just trust and reputation. And essentially what happened for this grower was the processor they were going to work with couldn't take the material when it was ready to be processed. They were scrambling. They couldn't find a single processor to take the entire harvest, so they ended up splitting their harvest between 3 different dryers. That meant that each dryer received the exact amount of the wet product, and actually it turned out on the same day. So the good news was that the first 2 processors got 90 and 95% yield. It was incredible. Bad news. Third processor, also an oral agreement, gets a 25% yield and says your product was crap. It was horrible. The reason why it's so terrible and we can't do anything with it, and you think it's not us, we didn't ruin it, your product was terrible to begin with. Scenario 2 is the more generic agreement, looks professional, looks like it has all of the fancy words you want those contracts to have: indemnity, terms, governing law in caps and bold and underlined, and who signs and things. But once we got to the delivery stage, we noticed that there were some really costly clauses for the grower that they didn't realize. Particularly, these contracts had storage fees that started the moment that the product was processed. There was no grace period for time to come pick it up. There was a percentage storage fee that applied as soon as the product came and was ready to be picked up. It put the entire burden on the grower to be ready at a moment's notice to go pick up the product, regardless of what they had going on with other parts of their business. There were also limitations on liability. And what we found by reviewing what looked like a very generic, very standard contract was the actual language of the contract wiped out all liability on the part of the processor for anything that happened to the product, down to if that building had burned down and the product had been destroyed, there was actually language in the contract that the liability was still on the grower. The processor had no liability for product destroyed on their premises, which I found pretty disturbing, and it also waived all warranties of any kind. And what I have seen a lot of growers be really surprised about is that this contract and these types of contracts also really severely limit the damages you can get if the processor destroys your product in the process of drying it, turning it into oil, and things like that. As I mentioned, there's issues with the limitations on liability, but specifically, there was a damages limitation. And the easiest way to explain this is a grower takes a certain amount of material to a processor. They need it processed, they need it dried, they're going to turn it into, I think I said pre-rolls. They've got a contract with a retailer for $2 million. As soon as they deliver those pre-rolls, they get $2 million. To the grower, that product is not only worth that value of the harvest and the time and money that went into it and what it could get on the open market, it's that $2 million pre-roll contract. When you have a contract that limits damages, that means if the processor destroys the product, this grower can only get back the market value of that harvest, not what they were going to get from that retailer. They're out the $2 million. They can't recover that from the processor. And in a worst case scenario, they might even face litigation from the retailer who thought they were getting $2 million in pre-rolls delivered to them. And even if they managed to avoid litigation on that front, they've burned a professional bridge that was probably really important. The other thing about the seemingly generic written contract was that it was missing a lot of really important terms. It had no information on how the material was going to be dried, no information on how the material was going to be tagged and identified when it went into the facility, and no information on how final payment was going to be made. There was also no provision for what the grower or processor were supposed to do at the end if the grower was unhappy with what the processor did, and no provisions for what the grower could do to reject the processed material and demand a refund. In scenario 3, we had a really detailed written agreement. It was beautiful. It had all of the terms that we had missing before, and detailed description of material to be delivered. It had estimated yields. Processor keeps all risk and liability while the material is on their premises. They're given a unique ID. The product is cataloged as it comes in. They have a third-party lab coming in to confirm everything's been processed, to give each side assurances that they haven't mixed up the product, that all the product's been delivered, to prevent diversion. And there's details for rejecting the product, and there's details for the payment schedule at the end and how things are going to be made. So, anyone have any guesses which contract avoided litigation, or the parties fighting over, the processor and grower fighting over the product? Any of them? None. All three of them ended up at the end of the relationship being not happy with the other side. In scenario 1, the processor saying it's bad to start. There's no photos or documentation. There's no tracking of the product. And the only option the grower has is to hire an attorney to go in and try and make the entire argument. Because it's just an oral agreement, they're going to be on the hook for their attorney's fees. They're going to be on the hook. They don't get to go to mandatory arbitration or mediation, which sometimes saves costs for people and gives you a path to some sort of resolution that's a lot faster than litigating. And there's almost no way they will be able to recover any compensation other than what the parties eventually agree the value of the product is. Scenario 2, it all came down to final payment. The parties just could not agree on whether or not the payment was supposed to arrive before the product was picked up, if there was a right to inspect the product, the processed material before the payment was made, or if those things could be done simultaneously. And so they ended up spending a lot of time and money on attorneys and a lot of anxiety trying to figure that out. And scenario 3, that beautiful, wonderful, detailed written contract that had everything we'd like to see, processor vanished with the product. The building's empty. No one knows where they are. Multiple growers have been affected. And unfortunately, one of the things that we're seeing in these contracts as well, and that the industry itself just needs to change and start understanding how valuable these crops are, is that the contract wasn't what attorneys like to call securitized, meaning the only recourse that this grower has is to file a lawsuit, get some sort of judgment lien, and follow this company around, and potentially the individuals who are arguably, hopefully, individually liable for what happened, and see if they have some sort of assets that can be what we call liened or attached in order to get them some money back. But the likelihood is they're not going to get anything back. So, interestingly, as I was working on this morning, I realized of all of these, the one that I thought was the worst ended up coming out the best. It was that grower who had oral contracts, who was scrambling, who had no choice but to go to 3 different dryers, that ended up with 2/3 of his harvest and things that he could actually sell on the market just by luck. It had nothing to do with planning ahead. It had nothing to do with like some genius strategy on his part. It just turned out that when he split his harvest between 3 different processors, he got lucky, and 2 of them did what they were supposed to do and got the high yield that he was expecting, and only 1/3 of his harvest was impacted by the fact that he didn't have a contract and he was scrambling at the last minute. So the question I'm sure you all want to know as growers, and even processors should be thinking about this too, because you don't want to get in this situation with a grower where you turn over product and then there's a fight over when payment is due and can they inspect it, and the product wasn't processed properly and it's not my product. Each side should want as much guidance and forethought in writing set out about how that part of the relationship goes. It protects both of you. So the things you can do, the most important part as you're headed into this next harvest season is to plan ahead. Don't wait till the last minute to look for dryers and processors, and ask the questions. Ask the questions about terms, about how delivery is made, about how you're going to be able to be sure that your product is the product that went in, is the product that comes out the other side, and what happens if you're unhappy with the work. Talk about any type of security that you can do. In some commercial contexts, there are liens that you can put on things. That part of the industry is going to have to get up to speed. But the good news is, as unique as the hemp and cannabis industries are, a lot of the UCC and contract terms, they translate really well. So in big ag, they've been doing these things for years. You wouldn't just turn over your product and hope that someone gives it back in the condition that you wanted it to be in. You would know what your remedies are. So look at the remedies in the contract, look at damages, consequential damages, and all of those things to see what you can do if you aren't happy with the product. And I mean, I'm an attorney, so obviously I like to have work to do. And one of the things that we do for a lot of our clients, and it's a very, very large part of our business and an important part of our business, is we review things before you sign it. Just because you're handed a contract and they ask you to sign it and they say, as soon as you sign this, we can get started on drying your product, doesn't mean it's not negotiable. It's all negotiable. Your product is your product. It's important to you. You worked really hard on getting it to where it's at, and you can negotiate those terms. It's not. I have a lot of clients who are newer to the industry who get really nervous when the other side wants to review a contract. That's okay. It's okay to get nervous, and it's totally okay to ask to make changes to a contract. Worst thing that happens is the other side says no, and you go and find a different processor. That's why it's important to plan ahead and start thinking about this before you get to harvest season. Again, negotiate and to have a backup plan. That grower in scenario 1 got really lucky and ended up being able to protect 2/3 of his harvest and only lost 1/3 to the dispute with the processor. And that leads to one of the last points, which is get creative. Just because, like I said earlier, just because the contracts themselves are in writing and you're being told to sign it, doesn't mean you can't come up with a creative solution or workaround that works for both of you. You can join with other growers to have a processing facility at some point. And you each know when you're doing your harvest, everyone gets to use the facility if that's possible. You can partner with a processing facility and have some sort of equity. You can create relationships that end up benefiting both you and the processor and protect your product. And just remember that sometimes even the best looking, well-negotiated agreement goes sideways, and there's not a lot that can be done to prevent that. There's always at least two sides in a disagreement and in a contract, and sometimes the other side just does not do what they're supposed to do. I don't think that the grower in scenario 3 could have done anything more. They had a beautiful contract, they did all the things they were supposed to do, and they got into business with someone who was never going to hold up their end of the bargain. So just because you end up in litigation doesn't mean that you or your attorney or anyone in your company who was involved in that process did anything wrong. Sometimes it's just the risk of doing business, and you learn from it and you move forward and put together a contract that makes more sense for your company. And that's my little disclaimer. And I will answer any questions anyone has. And if you have questions, please go to the mic. That's what the sound guy tells me. Anything? Was I that good? Really? Go for it.
Is there a good way to vet the people that we're entering into contracts with? Like, is there a system, can an attorney help us to do that, to review, the business practices of the individuals that are involved in the partnerships, for example?
An attorney can definitely help you review the contract and give you a sense of what, in particular, in terms of vetting. The short answer is not really. That it would depend on the size of the contract and the size of the investment to where you'd be able to get in the weeds about the other company's finances and things. Moving towards securitizing in the hemp and cannabis processing contracts would get you more basis to do that sort of investigation. But one thing an attorney can help you with is making edits to that contract, and when they send it to your processor or the company you're thinking about getting into business with, the response we get back to our proposed edits tells us a lot. If a processor or someone you're about to go into business with is really unreasonable about very standard, very basic, really equitable provisions being put into a contract, it tells us a lot. And we will tell you to run screaming from the room and find someone else. Or we will tell you exactly what the risks are and what our concerns are going into it, so that at least as you're going into the situation, you aren't surprised at the end if it goes sideways.
Do you know of any good resources for generic contracts between hemp and contractors? Is that something you go to an attorney to get? Is there like...
Sarah
I need
Battersby
to talk
does.
to you. Okay.
Yes, and we do have, I mean, I know I mentioned LegalZoom, and that's bad because I actually, oddly, UCLA is strange. I actually went to law school with one of the guys who started that company and realized it right as I said it, and I hope he's not mad at me. But it's not that I think getting a contract off some service like LegalZoom is a bad thing. I am wary about whether or not that contract will accomplish what you think it will. And the important thing is to have an attorney look at it, even if it's a template contract. It's a contract you got from the other side, and you tell the attorney what you want it to accomplish and what you're hoping it accomplishes and what the other side told you it would accomplish, and the attorney can make sure that it happens. And a lot of times we review contracts that we didn't draft, and we do exactly that. Tell us what you think this does, tell us what you want it to do, and we'll tell you how it needs to be edited or changed or whatever to accomplish that goal. Anyone else? Yes.
What are some of the top terms that you're seeing where there's a disconnect between what the parties thought they had agreed upon and what the contract says because they just signed a template agreement?
I think the primary thing that we're seeing is what happens if people are unhappy at the end. No one ever thinks they're going to be unhappy at the end of the process. Everyone's really worried about getting their harvest in, getting it dried, getting it processed, having that work completed. And there's very few contracts I've looked at where the end process of picking up the dried product, picking up the oil, making sure it's yours, making sure it was processed to the specifications it was supposed to be processed. A lot of the contracts are missing that. And that is where parties, and I am seeing the most dispute, and that's when a litigator like me gets called. At the end when someone's like, I went to go pick up my product, they wouldn't let me see it before I paid, so I don't know if I feel like they might have ruined it. Or I went to go pick up my product, that is not my product. I know that my product gets more than 25% yield, that's either not mine or they messed it up, and there's no provision in the contract for what they do in that scenario, and that is typically when I see it come to my desk.
I just wanted to say that I'm the sort of like hemp farmer on the other side of
Yes.
I've been working with Cultiva for ages, and I've been in finance for 20 years and hemp and cannabis for 5 years. Lots of contract work, lots of deals. So I write all of my own contracts based on what I know about extraction, farming, yields, potency, transport, storage, all of these things that are super specific to hemp. And then I send them to these guys, and they just make sure my language and my terms are what I'm looking for. But what I did for today's, I spoke earlier, but it was misnamed. So I've created this package of templates and models. And if you want to have access to those, if you just go to hempex.us, and you can just enter your email, and I will send them to you. But do not miss the last step. I would never go into a contract without my last stop being put it in front of an attorney. Yeah, it's hempx, HEMPX.us, and you'll just see enter your email field, and you can enter your email, and you'll receive these just template documents that cover the hemp piece, and then just go and get a good checkup. Adapt them, rewrite them.
Yes.
You'll have to edit them to fit your situation, and then take them to your attorney.
Yes, and that also does a lot. I know a lot of growers, especially, are worried about the cost of having an attorney on retainer, having an attorney to review these things, and doing what Sarah's recommending, and having a template that you know is written by someone that you trust, and then having an attorney look at it greatly and vastly reduces your costs as a grower at the beginning. Litigation is so expensive, and it's so expensive because the litigator comes in at the end of the process. I spend 40 to 60 hours at the beginning of litigation just getting up to speed on what happened, what the parties did, collecting documents, reviewing the documents before a complaint can be filed, before I can actually get into getting some sort of relief for my client. And that's because I wasn't involved at the beginning. It's one of the reasons why I went to Cultiva and was so excited to start with them is what they do is cannabis law. We are able to work on transactions from the beginning and be involved in them. And if they go sideways for some reason, I get to be a litigator still, which is a thing that I have a lot of experience doing, but I know what we did. And if you can afford to have an attorney review your contracts before you get into a relationship with a processor and before things are signed, it is worth the time and expense, and it is a vastly, vastly reduced expense.
So I know that every contract is unique to the situation, things like that, but in a really broad general sense, I'm wondering, what are some of, or maybe the most common red flag that would make you, when you're looking at a proposed contract, that would make you stop and go, something's not right?
Depending on the contract that we're looking at, I think, especially in this particular context, the thing that would have, in scenario 2, that generic written contract that looked harmless, like no big deal, if I had reviewed that before it was signed, that limitation on liability section would have had all of my red flags going. There's no way I would have advised that that be signed. The fact that that contract actually had a sentence in it that said, I think I wrote it down, we'll see if I can find the exact language. The exact language was that the grower assumes and accepts all risk of loss to the hemp while it is located at the processing facility. That is like dropping my child off somewhere where I think they're going to be safe and they lose them and they're going, well, you assume the risk of leaving them here. Didn't you read that part of the contract? No, you lost my child. I want to know where they are. You don't get to say that I don't get to know that information because it's in the contract. That sentence alone, I would have, there's no way.
You haven't checked into the hospitals lately,
No, but my parents have.
One thing I would just mention that it's kind of hard to go and look for a database of bad actors in the hemp industry for many, many reasons associated with liability. But if you join your local farmers, growers, whatever association, you then become, you get the resource of a bunch of people with experience, and then you can ask. So going with a recommended company doesn't eliminate all risk, but you can cut down the amount of time you have to spend running contracts through lawyers if you try to work with people you know are quality.
Yes.
And joining an association allows you to meet other people who know that if you don't. That's all I think.
Yes, no, absolutely. That's great advice. It's like with any other industry, the more people you know who worked with someone and had a really good experience, the more likely you are to have a good experience. It's why it's so important that everybody upholds their side of the bargain, because it really stinks when you worked really hard to establish your career and to establish your reputation in an industry, and then a contract goes sideways and suddenly you have this ding in your reputation and someone got their feelings hurt, or there's a perception that someone did something, underhanded or below board. And joining things like growers associations and getting to know your community and getting to know other people's experiences with the sort of company that you are looking to build a relationship with is really important to that. Anyone else? I know I talk really fast and I'm sorry.
Hey, Veronica, thanks for coming in today. Go Cougs.
Go Cougs!
This is a little bit of a sidebar thing here, but being that you're in the law side of it all, has there been any talk about co-ops being formed between growers and processors and such at all?
I'm sure there has been. I'm newer to these particular contract disputes and haven't been as down in the weeds, pun intended, with the hemp stuff as I should have been. So I'm sure there has been, but I haven't had any specific experience with it myself. I mean, it's big in certain industries for a reason.
Yeah, we're in those industries as well. That's why we're wondering if it'll come to this one.
Any-
With the union.
That is how it works. Any other questions? Thank you so much for coming. I love talking about this stuff. If you have questions, please feel free to come up and we can talk off the record.